I am speaking generally about Chapter 2, the permit approach, on behalf of Sea Bar Ranch. And my first comment is that it's noticeable they lack any substantive standards. You can't tell what it is the criteria would be for the grant or denial of any of these permits. To the extent that you look at the structure of your proposed rules, including Chapter 2, but not limited to Chapter 2, and in particular the notion of an exempt well versus a non-exempt well, it appears that you have a structure that does not recognize ownership in place of groundwater. I have been told, whether it's true or not, I don't know, but I have been told that you apparently have been advised that ownership in place is not the applicable standard in Texas law. I'm here to tell you that I believe to be an incorrect view. In the East case, in the early part of the last century, Texas Supreme Court announced two rules in one paragraph, so it's been kind of confusing. That first rule was ownership in place, and the second part of that paragraph talked about the so-called rule of capture. And Mr. Ellis has described the rule of capture, I think correctly. It is not a rule of property ownership. It is a rule of non-liability. If I drill a well and happen to drain by my production your well on adjacent land, you can't sue me for it. That's the function it plays. But ownership in place is the rule. It was announced in East. It's been recognized in subsequent Supreme Court cases. And if there's any concern that it's about not to be the rule, let me point you to the case that came out of the Fourth Court of Appeals in San Antonio, the Hamilton Trust versus City of Del Rio case, where that court point blank said ownership in place is the standard that applies in Texas. Del Rio was not happy with that result, and they petitioned the Supreme Court to take that case and argued against ownership in place. The Supreme Court, after briefing, declined to take that case. So the most recent clue we've gotten in the last few months is that the Supreme Court, given a chance to recognize something other than ownership in place, declined to do so. The clue is that ownership in place for the last 100 years has been the rule, and it's still the rule. And you need your rules to recognize that. Thank you.
Ms. Falk, are you turning in written comments as well?
I have not.
Do you want to ask a quick question? Okay. Your comment is that the rules don't recognize ownership in place. If you wouldn't mind, I would like to get some written comments from you about where and how you think we ought to do that.
All right, I can do that.
I appreciate that.
I appreciate that.
Sure.
Thank you, sir.
Rob Lindsay is going to speak again in reference to the rules.
This is Rob Lindsay, City Manager, for the record. Again, the City of Goldthwaite objects to the numerous provisions contained in the plan, as more fully explained in the handout, in the rules, as more fully explained in the handout each of you were supplied a copy with. These rules do not reflect the desires of the people nor comply, and we believe, the current water law. We would encourage you to delay any vote on these rules pending resolution of the numerous issues pointed out in the handout. Also, point out in the handout, we have concerns about the election laws and the laws that were followed with respect to the election of this board. One of the things that's troublesome for the city is that under these rules, all the wells in the city are probably on less than 10 acres. They're going to be required to have an operating permit that they apply for every 3 years and provide an annual pumping report. That means they're going to have to put a meter on their well to comply with these district rules as proposed. In addition, most city lots are so small, you can't drill a well 100 feet from all your neighbors' property lines. So there will be no more wells drilled in the city by the individual landowners. That's contained in these rules. I could go on, but I'm going to yield my time to our attorney, and he can represent some additional comments for the city. Thank you.
Mr. Johnson.
Thank you again, Russ Johnson. I was retained by the city to review the draft rules as well. And on the election issue, I just want to comment that the rules contemplate you'll have elections in even numbered years. Enabling legislation describes a process where you'll have elections in odd number of years. I think that needs to be addressed before you can move forward, particularly with the kind of aggressive rules that you're talking about. But The fundamental concern that we have with the rules has already been touched upon by Mr. Fogg, but let me emphasize that. The rules require, these draft rules now require any owner of a well in this county to come in and register that well within 60 days. You make a distinction in the rules between exempt wells on acres on tracts larger than 10 acres and on tracts less than 10 acres. That implies there's some importance to having 10 acres, but the rules don't describe what that importance is. It's implied that in the future, you will not have the right to drill a well on less than 10 acres for domestic purposes, but the rules don't say that. Worse, the rules provide no objective criteria for determining how and when or what kind of permit will be issued when applied for. There is nothing in the rules that addresses historic use. In your management plan, you say you're going to protect and recognize historic use. There's nothing in your rules that address historic use or protection of historic use. In fact, quite the contrary. The way the rules are drafted, you clearly reserve the right to limit existing use to achieve your managed available groundwater number.
I think that's just Mr. Ross.
Yeah,
Okay, go ahead.
The idea of registration, let me give you an example that Greg knows very well. The Edwards Aquifer Authority legislation likewise calls for registration of exempt wells within the Edwards region. Granted, it's a 5-county region, not a 1-county region. That legislation became effective in 1996. The Edwards Aquifer Authority is still in the process of registering the exempt wells within the Edwards Aquifer Authority, 13 years after the adoption of the legislation and implementation. That is not a process in this county that can be completed in 60 days. Right now, the rules say if you own a well, you've got to come in with one of these forms within 60 days. If you don't, the rules don't say this, but they imply you lose that exemption. So these rules would require a stampede by every landowner in here to file some kind of form to ensure that they maintain what should be a recognized status as an exempt well. Non-exempt users are treated even worse. Non-exempt users, municipal, industrial, and irrigation users, have to come in and make an application for an operating permit. There's no criteria for issuance of that permit in your rules, and worse, you reserve the right to consider that permit based upon 4 articulated reasons, and you don't even ask for information from the applicant on those 4 criteria. For instance, is the amount of use reasonable? You reserve the right to make that judgment, but you ask for no information from the applicant about the reasonableness of the use. So the point is, you have a set of rules that allow for, I'm not saying they will be, but they allow for arbitrary decision making. Instead, you should have a set of rules that are predictable, that are understandable, so that your regulated community knows when they come in for and make an application, how they'll be treated and what the criteria will be for deciding if they should get a permit or not. So as they stand today, I believe they are fundamentally flawed. They are challengeable if you attempt to enforce them. And that's the final thing I want to comment on. Your rules contemplate enforcement, and Chapter 36 does give you enforcement authority. But you are suggesting in these rules that violators, someone who didn't file one of those forms, could be subject to a $10,000 a day penalty. That, I believe, is absurd. Thank you very much.